The sole purpose of qualified immunity is to give cops a get out of jail free card. When you look at the history of qualified immunity, you can see how far the Supreme Court has gone to help cops who abuse and violate the rights of black citizens. Let me try to break down for you what has been a decades-long march towards protecting cops and disregarding citizens' rights. This will be like a mini law school class, but afterwards, you'll have a much better understanding of why qualified immunity is so dangerous. The court created qualified immunity out of the thin air in 1967. Qualified immunity is not mentioned anywhere in the Constitution. The court made it up. The basis for qualified immunity was good faith, meaning that it was meant to protect cops who act in good faith. But since then, it's been applied even when cops act in bad faith. It's used to help cops get away with horrific acts, so long as there was no previous case that said that they couldn't do it. A 1967 case called Pearson versus Ray is where qualified immunity was created. But the interesting thing is that the facts of Pearson and what led to the creation of qualified immunity had nothing to do with police officers using excessive force and brutalizing citizens. Pearson involved 15 black and white ministers who went to Mississippi during the Freedom Rides of September of 1961. When they were asked to leave a coffee shop, they refused and were arrested for breach of the peace. They were found guilty and sentenced to 4 months in jail. The law that they were charged under was later found unconstitutional and their cases were dismissed on appeal. They sued the police for violating their rights. A jury found for the officers and the ministers appealed. The Supreme Court said that the officers were entitled to relief under this new doctrine that they were creating called qualified immunity, because otherwise police officers who acted in good faith will be held liable if they mistakenly believe that the law authorized arrest. The court said nothing about excusing cops who beat and brutalize citizens. The problem with this good faith approach is that now it's been extended to bad faith acts. Now, so long as there was no prior court decision saying that a particular course of conduct was unconstitutional, officers can get off free for bad acts, even if they acted in bad faith. So how do we go from protecting good faith mistakes to allowing for any and everything? The Supreme Court has continued to strengthen qualified immunity since it created it out of the thin air. Each time they strengthen it, it emboldens cops to act unconstitutionally and it endangers black and brown lives. To make it easy for cops to get away with bad acts, in a case called Harlow versus Fitzgerald, the court said that an officer's intentions don't matter when it comes to qualified immunity. All that matters is clearly established law. They said that cops are too busy to talk about their intentions. A case called Baxter versus Bracey is another good example of qualified immunity and how it protects bad cops. In Baxter, the appeals court upheld a grant of qualified immunity to officers who released their dog on suspects that were sitting down with their hands up. The court said that the officers' actions were unconstitutional, but qualified immunity had to be granted because there was no prior decision saying that an officer could not release a dog on a person who was sitting with their hands up. I'm not making this up. Another example was in a case called Kelsey versus Ernst, where qualified immunity was granted to an officer that slammed a woman who was nonviolent and non-threatening to the ground, breaking her collarbone and knocking her unconscious. Even though there was case law saying that you couldn't use force on someone who was nonviolent and posed no threat to the officers, qualified immunity was granted because there was no case law saying that an officer couldn't use a takedown maneuver to arrest someone who ignored the instruction to walk towards the officer and continue to walk away. In 2009, the Supreme Court made it even more difficult for victims of police misconduct and easier for the police by putting the burden on victims to find a case stating that it was clearly established law to act in a certain way. Here's the problem with that. So many things will have to happen to find a case that is identical to yours. It would mean that someone's rights will have to be violated in the exact same way that yours was, which is virtually impossible because no two things happen the same way. Another example of how the court protects cops and bolsters qualified immunity, the court changed the rules for when you can appeal a decision. Typically, you have to wait until the end of a case before appealing a court ruling. You have to wait until a final judgment has been entered. Not for qualified immunity, though. Cops can appeal a denial of qualified immunity before the end of a case. This means that in the middle of a case, the police can file an appeal and cause months or even years of a delay to a case while the appeal is considered by the appellate court. The Supreme Court and those that defend qualified immunity say it's necessary because it protects officers who make mistakes from bankruptcy. But very few settlements or judgments result in officers paying money from their pocket. One study found that cops paid 0.02% of more than $735 million that plaintiffs received in settlements. So the argument that officers need qualified immunity to protect them from bankruptcy is false because they don't pay or contribute anything to these settlements. Qualified immunity is simply a doctrine used to protect cops in the age of mass incarceration. All of these bad decisions granting cops qualified immunity are part of a larger trend that began in the 1980s when the war on drugs and tough on crime era began to unfairly target communities of color. Aggressive policing and combating crimes often leads to citizens' rights being violated, and the court created ways for cops to get away with it. That's all qualified immunity is designed for.